A very good morning to all my dear students. And I'm so happy to see the enthusiasm that has been shown by lovely morning wishes. And yes, Komlakshi, even I'm excited. As we all know, today is the last class for this batch session. So definitely all your queries, problems, I'll try my best to take up each and every question as far as possible because we are meeting for the last class today. But children, before that, it's a very important session that we have today. Why? Number one, we're going to complete the Companies Act. And number two, we have to do the question papers from the examination as well today. Because we'll be winding up with the syllabus. We have types of companies also, few companies that were left. So we will be taking up those types of companies first. And also we'll try to take up the questions from the examination. After that, we'll be talking about the last part of Companies Act, that is incorporation of a company. And thereafter, two very important documents regarding your Memorandum of Association and Articles of Association. Yes, Sangeeta Chaudhary, I'm so happy to read that you're always excited to attend my class. Thank you so much. Good morning, Sumit, Kshitij, Misha, Karma, Jyoti, Mr. Abdul. Abdul, you're still stuck with 120 days. Definitely, it is now provision of 120 days for OPC. That's correct. Talat, Vanshika, Chandan. Oh, Chandan Shah, don't be sad. I will definitely be in touch with all of you. You can ask me your queries. I'll try to answer your queries. No, don't worry about that. Good morning, Jaspreet, Sridhar, Ganga, Jyoti, Bhumika, Vidhi, Kamlakshi once again, Ankit, Piyush, Vidhi, Chetan Gadia, Pratibhan. Pratibhan is the first time I'm reading this name. Good morning, Dinesh, Shambhavi, Manisha, Hira Hussain, Ajit, and Mansi Kumari, Vidhi Bagla, Piyush, Ankit, all of you. Very good morning, children. Ranjit Singh, Krishnottama, Kashish, Sanket, Ankit, and all those who have sent beautiful wishes. Mayur, Nikhil, Barna, a very good morning, children. So without wasting much of time today, we have very less time because 2 hours and we have to complete the syllabus also. And my students have certain queries which I also need to solve. So let us start where we left. So children, we have already done the classes of companies limited by shares and guarantee. We also discussed one examination question I told you where you can mention about the Narinder Kumar case and you can tell the differences between the company limited by guarantee and shares. That is the only difference is companies limited by guarantee has a certain privilege over the companies limited by shares. After that, OPC is very important concept. All those who are asking, ma'am, how to revise, how to prepare. Yes, direct questions also come from the study material, Bhumika, definitely. And Mayur is asking, how can we score good marks? So my humble request, learn your study material, grab all the information, go through my PPTs, try doing all the MCQs and tests that has been given to you, and you will score good marks. The only thing is, study material is the Bible, students. Nothing is going to come out of the syllabus. Everything, whatever is given in the study will be coming. Those who are wondering about CA Inter, let's clear CA Foundation. Then CA Inter also will be doing together. Don't worry about that, okay? Dissolution of assets and distribution, Sanket, that was the part of partnership. Yes, it is covered under the dissolution of partnership. About winding up of the company, that is a CA Inter syllabus. We don't have to get into this. Vanshika Gupta, you can send me the queries in this session itself, not to worry. All right, Palak Gupta. All right. Okay, let's move ahead now. Let's start. Section 19, Dinesh, we are still stuck with Partnership Act. So remind me once we are done with the syllabus of companies, then we'll go to that. So OPC children, you have to remember the latest amendments that we discussed and whatever points we have discussed in OPC. Public and private company also was very well discussed in the previous class. The major things to remember, private company has minimum 2 members and maximum 200. So today we'll be doing one important case law from examination, which will make the number of members counting point clear from private company. And if I say I'm inviting subscription from the public, then it immediately becomes a public company. If I'm restricting transferring of shares, I'm putting a prohibition on invitation of public, then only I'll be counted as a private limited company. Holding and subsidiary companies, very, very important concept. Now, when I am a holding company and which company becomes a subsidiary? Since you all keep asking about the examples, these are major international acquisitions about subsidiaries like Tata Steel Thailand, Tata Steel Europe, Tata Sponge Iron Limited. So these are the examples of subsidiary companies. Now, how do I become a subsidiary company? So holding company, another name given to a holding company is a parent company. So remember, I was telling you that day also, if your public company, if your parent company is a public company and you have a subsidiary which is a private limited company, then that specific subsidiary is also deemed to be a public company. So all of you were wondering now, what is actually a subsidiary? So today I'm going to answer you how a subsidiary is formed. So say, for example, a company A Limited company is holding the composition of BOD. BOD means Board of Directors. So if A Limited is controlling the board of directors of B Limited, ma'am, what is the meaning of controlling the board of directors? So A Limited only decides who is going to be appointed at the board of B Limited, how the removal of directors will be held. Entire control of the board of directors is in the hand of A Limited. In such a case, point number 1 says A Limited becomes the holding company and B Limited becomes its subsidiary. Means it is appointing the directors, it is removing the directors as per the directions of A Limited. So where A Limited is trying to control the composition of board of directors, then company which is controlling the composition will become holding company and the other company becomes the subsidiary company. The second case is or. So there is a very important word, or. Either I am controlling the board of directors or I am holding more than half of the total voting powers. So if A Limited is holding more than 50% of the share capital of B Limited, then also A Limited will become a holding company and B Limited is counting as a subsidiary company. And point number 3 given in the study material is subsidiaries subsidiary. So if B is subsidiary of A and B is further holding a company which is a C Limited, then it says this subsidiary will anyways be a subsidiary of A Limited also. So if I am a parent company, I have a company under me and that particular company also has a third company under it. So this third company also becomes my subsidiary. All right. So don't worry, we'll be taking all the examples given in the study material. What you have to remember in the case of holding and subsidiaries, children, that holding company can either be controlling your composition of board of directors or I'm controlling your voting powers. Okay. So either of them case, if I say I am not holding more than 50% share capital, but I control your composition of board of directors, do I still become a holding company? Yes or no? Yashoda, composition of board of directors means I am deciding who has to be appointed at the board of directors of the other company. How their board is to be appointed, how many number of directors will be there. Every control is in my hand. Okay. All right. Tell me, children, if I say that I am not holding more than 50% share capital, but I am controlling the board of directors of C Limited, my company is controlling the board of directors of C Limited, do I still become a holding company? Yes or no? All those who have answered yes is correct. Don't expect me to take names of all those who have answered correctly. Reason being, we have very less time. Yes, Abdul, you can say that any company which is, if Reliance is having more than 50% of share capital in any other company, then that company will become a subsidiary of Reliance as well. That's absolutely correct. So any company which is holding one or more companies, there can be a company, more than one companies also, which can be my subsidiary. It's not that I'm just having an interest in one company. I can have more than one subsidiaries as well. Now, section 2 subsection 87 specifically tells you that what is the meaning of company. My all children knows company means any body corporate. एक ऐसी body, corporate body जिसकी separate existence है. What is the meaning of body corporate? You remember the characteristics of company. When the company is formed, it has its separate existence. Means it gets the body of a company is a body corporate. It gets a corporate kind of structure. एक building दिखाई देती है. It is an artificial person. There is no person whom you can see, but yes, you can say this is the Tata Steels Limited company. This is the body corporate. So company means body corporate. जहां भी word लिखा होता है उसका मतलब होता है company has a separate legal existence. Subsidiary in relation to any other company means a company in which holding company either is controlling the board of directors or having more than 1/2 of the total voting powers, either on its own or with by one or more subsidiaries. So if Harleen ma'am is having a company A Limited and Prakhar is having a company B Limited, so if together A and B Limited holds more than 50% of the shares of C Limited, then C Limited is subsidiary of A as well as B Limited both. So I can either hold the directly 50% of the share capital, or I can hold it with my other companies. Then also it becomes a subsidiary. Excellent. All those who have answered it correctly, very good. Yes, Sarthak Agarwal, the condition, any one condition, if it is fulfilled, then it becomes a subsidiary. Very good. Yes, Muhammad Ali, even if I was not holding more than 50% share capital, but even if I'm controlling the board of directors of another company, then also I become a holding company. So this is just a definition which has been given. What is a subsidiary company? Now, somebody was asking them, what is the meaning of composition of board of directors? So composition of board of directors has been clearly defined over here. It says, it shall deem to be controlled by another company if we are exercising the powers at its own discretion for appointment and removal of all or majority of the directors. So if I'm appointing your directors, I'm deciding who will be your directors, how the directors have to be appointed, how they have to be removed, entire composition. Composition means numbering of board of directors, कैसे board of directors function कर रहे हैं, कितने directors आपने रखने हैं board पे, कितने directors को remove करना है. If I am trying to control those things in your company, then I am your holding company and you are my subsidiary. Let us read few examples. It says A will be a subsidiary. What does it say? A will be a subsidiary of B if B controls the board of directors of A. So what does it mean? A can, without or consent or approval of any other persons, B can appoint or remove majority of directors of A. So in example number 2, children, quickly tell me which is a holding company and which is a subsidiary company. It says B is controlling the composition of board of directors of A. That means B is either appointing or removing the directors. So which becomes the holding company and which becomes the subsidiary company? Quickly tell me. If you give me the correct answer, that means holding subsidiary. 3 marks or 5 marks or 6 marks question is in your pocket. You have understood the concept. Discretion means, Vanshika, discretion means at their own choice. I have the power to exercise. I have the rights. I can do it. In case of a death, Pooja Swami, in case of OPC, you remember we named the nominee, so that nominee will be taking care of that OPC if the one person dies. Okay, children, are you giving me the answers? So all those who have given A will be a subsidiary of B. So here B is a holding company and A is the subsidiary company. B is a holding company and A becomes the is the subsidiary. समझ आ गया बच्चा? Because B is controlling the board of directors. So excellent, those who have given the correct answer. B is the holding company and A is the subsidiary of B. Many of you have answered B is the subsidiary. Deep Shikha, Kashish, wrong. Bacha, pay attention. Very good, Ajit. A is the holding, B is the holding company and A is the subsidiary. Bacha, यही चीज है, आपको ध्यान से देखना है what we are talking. Somebody is talking about C. Shivam Gupta. Why are you talking about C company? In example 2, we only have 2 companies, A and B. Why did you jump to C? He's saying B is holding C subsidiary company. Okay, B is holding A subsidiary. Kushagar Nath, that is correct. Sarthak Agarwal is correct. Vanshika, Aditya, Simran Kaur, all of you are correct. So please, children, you have to pay full attention. So Palak Gupta, first understand how the holding and subsidiary becomes. Then we'll understand if we have a further subsidiary, then what happens. Lakshmi, that's correct. Sanket, that's correct. All of you, those who have sent the correct answers, apart from 2 students, everybody has sent a correct answer. Pragati, Chandan, Deepshika, all of you, Muskan, Nikhil, it's correct. Similarly, example number 3 is also clear. A will be subsidiary if B is holding more than. तो दोनों example उसने दे दिए. और की condition है या मैं board of directors control करूं या मैं more than 50% of the share capital hold करूं. I become your holding company, you become my subsidiary. Now example number 4, which really bothers you. Let's go through it. It says B is a subsidiary of A and C is a subsidiary of B. क्या बोला इसने? B is a subsidiary of A. That means A is the holding company and B is the subsidiary company. And C is a subsidiary of B. So that means B is a holding company and C is a subsidiary. Now it means C will also be the subsidiary of A. Father, son, his son. So his son also has a relationship of grandfather, no? Parents, generations. So you can just link it like that. So A ki subsidiary B, B ki subsidiary C. So C will become subsidiary of A. If C had a further subsidiary D, then D will be subsidiary of B as well as of A. Flowchart बना लेना अपने notes में अच्छे से. मेरा थोड़ा untidy आता है because I'm using the mouse. So when you will make it neatly with your nice, beautiful color sketch pens in your notebooks, you'll never forget it. So write down all of you. If A is holding B, A is the holding company, B is the subsidiary company. If B further has a subsidiary C, C will be having the holding company. C will be the subsidiary of A as well. And if C is holding further D, so D will be subsidiary to B as well as A. Remember the generations, okay? Clear ho gaya? Now this beautiful amendment we have already discussed. A private company which is a subsidiary of public company shall deem to be a public company. So if I am ABC Limited, and I am holding a company, I am a holding company and my subsidiary is B Private Limited. Then children, if B Private Limited is my subsidiary, then I am not saying Companies Act 2013 says that even though subsidiary company continues to be a private company, although B Private Limited ही रहेगी, it will have 2 members minimum, maximum 200. It will be having a prohibition on the restriction on the transferring of shares and inviting the public. But for the purposes of section 2 subsection 71, it shall deem to be a public company. So if I am an Indian citizen and my child is also Indian, even if he wants to be an American, when he grows up, he's influenced by a Western culture. But still, if I am a parent company, I am an Indian, then my subsidiary is also an Indian. कहने का मतलब, even if you are a private limited, since I am having more than 50% of the shares in you, since I am having control on the composition of board of directors, therefore this B Private Limited shall deem to be a public company. इस कंपनी को भी public company माना जाएगा because it is a subsidiary of a public company. क्यों माना जाएगा, कैसे माना जाएगा, अभी के लिए सिर्फ ये याद रखना है, कंपनीज एक्ट 2013 सेक्शन 2 सबसेक्शन 71 में ये लिखा गया है. कैसे होता है, क्यों होता है, सीए इंटर के लिए थोड़ा सा छोड़ देंगे हम, ठीक है, सीए इंटर में डिटेल समझेंगे. Another is associate company. So without even doing, you remember in the last MCQs, I tried to taught you about associate company also, where you are having more than 20% interest. अब यहाँ पे क्या बात करते हैं, वहां पे he was talking about the board of directors and voting power. Here it says any company in which you have a significant influence, which is not a subsidiary of the company, and it also includes a joint venture company. Joint venture means jointly when you have set up a company for a certain purpose. Venture means a particular purpose, a particular business for which you have set up a company. You have made a joint arrangements with another person. So here it says we are not having more than 50% control. Here he is talking about the word significant influence. Ma'am, what is significant influence? हमें क्या पता ये क्या मतलब बना significant influence? More than 50% share तो समझ आया, controlling board of directors भी समझ आ गया, but what is significant influence? So children, significant influence means if you are controlling at least 20% of the voting power, or you are participating in the business decisions of another company, then those companies are considered to be the associate companies. So it can be an associate companies and even joint venture companies. It says where you have jointly held, the parties are having a joint control or arrangements to the net assets of the arrangement, then that is also covered under the associate companies. So what we have to learn in case of associate companies, section 2 clause 6 says that if A Limited is controlling 25% of the voting powers in B Limited, What did I say? A Limited is controlling at least 25% of the voting powers in B Limited. Do you think A and B becomes associate company? I know you all know that. Ma'am, answer is yes. But if I say, let me just erase this 25%. I say A Limited, ab dhyan se suno. A Limited is holding 15% of the share capital in B Limited. So ma'am, 50 bhi nahi hai, 20 bhi nahi hai. So no ma'am, they are not associate company and neither they are holding in subsidiary. But I say A is controlling and is participating in all the business decisions. How B Limited is going to do the business, how the directors are appointed, what kind of clients they're going to have. A Limited is entirely controlling and participating in each and every business decision. Then children, even if it is 15% shareholding, yes, A and B will be a associate company. So two things you have to see for a significant influence. Either you have 20% of the voting power or you are controlling the business decisions. Both the cases you become an associate company. And ma'am, joint venture is also covered. Yes, children, joint venture is also covered under associate company. What share capital you have to count? It says both the share capital, paid up equity share capital and preference share capital. The total of that is to be counted in the total share capital. So how I have to calculate 20% of what? 20% of the paid up share capital plus the preference share capital. This will be considered as the total share capital. Say, for example, if it is 100 crores. So we have 50 crores paid up share capital equity. If we have 50 preference share capital, so what will be the total share capital? 100 crores. Iska 20% मैंने देखना है, that in order to find out the significant influence. Sameer saying that's correct. Nominee will take over in case of the death of an OPC. Okay. Total share capital. Mile Murugan. Please pay attention. I'm just teaching the same topic. Total share capital means the entire paid up share capital plus the preference share capital. So if 100 crores is the total share capital, then 20% we have to see this 2 crore will be considered as the interest for the significant influence. All right, children, this is how you have to understand how we have to calculate your 20%. Now, another amendment that they have in associate company is Ministry of Corporate Affairs has clarified that shares held by a company in another company in a fiduciary capacity will not be counted for the purpose of determining the associate company. So if you're having any fiduciary relationship, any fiduciary capacity, if the examiner has specifically given you that if I am holding, so MCA, Ministry of Corporate Affairs means MCA. So in 2014, a clarification was given that if any company, if A Limited is holding shares in B Limited in a fiduciary capacity. So if I'm having a fiduciary relationship, a trust and mutual confidence relationship, then that shall not be counted for finding out the associate relationship. Clear? So any shares held in the fiduciary capacity shall not be counted for the 20% holding. Now let us pay attention. Here comes your answer to the preference share capital, how it has to be calculated. Ruchi Bajaj, when you pay attention to this question, you will understand. Mansi Kumari is asking me when will the admit card come. Bacha, this is some query related to administration. You can check with them. Okay, let's move ahead. So A Limited is a public company and it is holding 23% of the share capital in B Limited and 15% share capital in C Limited. So different companies ka naam aa raha hai. A Limited is holding 23% of share capital of B Limited and 15% of share capital of C Limited. So children, do you think A and B are associate company? Yes, ma'am. You just taught us that if you are having more than 20% of the share capital, therefore B Limited will be known as the associate of A Limited because it is holding more than 20%. Clear ho gaya? However, C will not be an associate company because the requirement of 20% is to be seen. Now, if I would have said all those who are stuck in fiduciary capacity, please listen carefully. Samriti, Aditya, Mayur, everybody. If I say that I'm holding the interest in another company for 12% share capital I'm holding and 20% I'm holding in a fiduciary capacity. So will I become an associate company? Yes or no? If I say A Limited is a public company and it holds 12% of the share capital of B Limited and 20% of the shares are held in the fiduciary capacity. Do we become an associate company? Yes or no? Tell me fast. Fiduciary relationship, basically relationship of trust and beneficiary. You must have understood in Indian Contract Act how a trust and beneficiary relationship is built. So if you're a trustee of a company, if you're having that kind of a beneficiary relationship, then that 20% is not to be counted, children. All those who have answered, no ma'am, they do not become associate company, absolutely correct. So examiner will specifically give you such kind of a situation that if I am holding on the basis of a trust and beneficiary relationship, you remember trust, you go back to your Indian Contract Act, you must have revised how a trust and beneficiary relationship, even in the chapter of consideration, you must have discussed about that. So fiduciary capacity means where you're having a trustee and beneficiary relationship. If you're having such kind of investment in a company, then that will not be counted for having an associate relationship. So we will say A Limited is only having 12% of the share capital. Excellent, Shivam Gupta, Kashish, Jyoti, Dinesh, Sarthak, Misha, Payus, Manisha, Vanshika, Samriti, all of you have given the correct answer. Okay, so then that means only 12% interest needs to be seen. Therefore, we are not an associate company. Okay, Vidhi Bagla, you have written yes, that's wrong. It was no. Okay, now let's move ahead. So listed companies now, children, on the basis of capital, listed and unlisted companies are very, very simple. Nowadays, you must have been hearing so many of trading goings on the recognized stock exchange. So you all know many times I have heard children also invest the securities in the listed recognized stock exchange. So the company which has its security listed on the recognized stock exchange, that is known as listed companies. What is a stock exchange? Where trading of shares occurs. So if you have taken up certain shares, mutual funds, and you keep on checking the price, how the trading is happening. So all the listed companies have to list the securities on the stock exchange. So as per definition which is given, it is a company whose securities are listed on the recognized stock exchange. They are known as listed companies. The word securities, now what are securities? But securities has been defined under section 2 of the Security Regulation Act. तो ये सारा लिस्टेड कंपनीज की जो सिक्योरिटीज है, शेयर्स हैं, इन सबको कौन रूल करता है? सिक्योरिटीज कंट्रोल रेगुलेशन एक्ट. मैम व्हाट इज सिक्योरिटीज कंट्रोल रेगुलेशन एक्ट? वी स्टडी इन सीए. बिल्कुल लिमिटेड इंफॉर्मेशन जो आपकी स्टडी मटेरियल में दी हुई है, हमने सिर्फ वो ग्रैब करनी है, इसके बियॉन्ड जाना ही नहीं है हमें, क्योंकि अभी हमने फाउंडेशन क्लियर करनी है. सीए इंटर में somebody is waiting to teach you about all these things, so don't worry. अभी के लिए मैम लिस्टेड कंपनीज whose securities are listed on recognized stock exchange, very good. Where is security is defined? Securities is defined under section 2 of the Securities Contract Regulation Act. Example कर लेते हैं. Scan Steel Roads Limited is a public company whose shares are on the stock exchange of Kolkata. Therefore, Scan Steel Rods is a listed company. So if Reliance is having its shares and you're investing in the Reliance shares, you're checking how much my investment is increased. So Reliance is a listed company if its shares are on the trading of the stock exchange. So whatever companies are having their shares are listed in the stock exchange, that becomes a listed company. Reason for calling it listed is because the company and stock exchange have signed a listing agreement. Point number 1 हमने करा. The companies whose shares are listed on the recognized stock exchange, they are listed companies. What is securities? Given under section 2 of the Securities Control Regulation Act. Ma'am, why they are called? Point number 3. Why they are called listed companies? Because company and stock exchange, they have signed a listing agreement for trading of shares in the capital market. So there are trading of shares which is happening, and for that we need to sign the listing agreement. So if your company has signed that listing agreement, therefore it is known as a listed companies. And what are unlisted companies? भाई जिसके shares नहीं है stock exchange पे, वो listed companies. Any company other than listed company is an unlisted company. Any company other than a private company is a public company. So simple definitions you have to learn. Now, what is government company? Again, a very, very simple definition. What is a government company? So if A Limited is a company which is having 51% of the share capital is held by investment or partly by central and state both, then A Limited will consider as a government company. Simple definition. Percentage of share capital, how much we have to see is the most important part. 51% of the paid up share capital. 51% of the paid up share capital. What is paid up share capital over here? It means total voting power where the shares with differential voting rights have been issued. What is DVRs? That we will do when we'll talk about the topic of shares and debentures. Differential voting rights की short form होती है DVRs. So it says where total voting power, even if you have given the equity shares with differential voting right, that will also be counted for the purpose of paid up share capital. So paid up share capital, children have to learn the total share capital either held by central government, state government, or both of them are jointly holding. Also, a subsidiary of such government company will also be a government company. So if I say government is holding 50% of the share capital of A Limited. ध्यान से सुनो, टेस्ट ले रही हूं साथ के साथ because आज मिल रही हूं तो फिर आज ही रिवाइज कर लो so that you just have to open your books and read it and learn it. That's it. If government is holding, central government I'm saying is holding 50% of the shares in A Limited, will A Limited become a government company? Yes, ma'am, or no, ma'am? No, Kashish, you don't need to refer any other book. Even if you want, you may, but study material, if you are referring, that is well and enough. And even, yes, my notes, you can refer, that's fine. Vanshika Gupta, DVR, I will make you understand in the equity shares. Excellent, Sameer. Correct answer. Definitely, Shubham Chaudhary. It includes government companies also. Manisha, I will definitely try to take that. Shares, debentures are the securities. Yes, Jaspreet Kaur, that's correct. Okay, are you sending me the answer for this one? Only Sameer Dubey has sent the answer. What about others? So if I say government has invested 50% of the share capital in A Limited, so A Limited becomes a government company, yes or no? इतना टाइम क्यों लगता है बच्चा आप लोगों का आंसर आने में मेरे पास? Let me check it on the other device. Okay. Very good. Excellent. No, ma'am, 51% of the share capital has to be seen. Excellent. There is not a single child who has given a wrong answer. It will not become a government company. Only one, Komalakshi, 51% share capital has to be seen. Yes is a wrong answer. Everybody has answered no, ma'am. It does not become a government company. Now listen carefully. This was the share capital which was held by central government. And children, if I say, and also state government holds 5% of the share capital of A Limited. So if central government is having 50% of the share capital in A Limited and state government is holding 5% in the share capital of A Limited, then therefore you will say, ma'am, total 55% stake is being held by government. Then yes, A Limited will become a government company. Samajh gaye? Good. So government company is clear. Foreign companies. Foreign company means any company which is incorporated outside India, but it should have a place of business in India, either by itself or by an agent, either physically or on electronic mode. So, aajkal Samyak Jain, I was waiting for you to come. Correct answer. Good. Vridushi, why are you saying it will become a private company? We were discussing whether it becomes a government company or not. When the word limited is written, it is always a public company. With word private limited is written, then it becomes private limited. Yes, Kshitish Kumar, that's correct. Yes, now Sarvesh, the minimum requirement becomes 51% is there, then it becomes a government company. Good. Good, children. I enjoy when you answer me back and that to correct answers. Very good. That means you're paying attention. अच्छा आप सब फॉरेन कंपनी में आ जाओ. गवर्नमेंट कंपनी आपको समझ आ गया. वो एग्जांपल समझाने के लिए थे. जब रिवाइज भी कर रहे होगे रिकॉर्डेड लेक्चर एक बार दोबारा सुन लेना, नोट्स बना लेना, लिखते जाना जो भी एग्जांपल्स डिस्कस कर रहे हैं, कभी नहीं भूलोगे. ठीक है. अब फॉरेन कंपनी इज अ कंपनी विच इज इनकॉर्पोरेटेड आउटसाइड इंडिया. तो यूएस में चले जाते हैं. मोहम्मद अहमद मेड अ कंपनी in USA. So Mohammed Ahmed made a company in USA and he appointed Abhinav Kumar. So he said, Abhinav Kumar, you will be acting as an agent and you will be running the business in India as well. So Mohammed Ahmed opened up a company in USA with the name of A Limited. And also this A Limited is having a place of business in India, which Abhinav Kumar will be handling. So can you say A Limited is a foreign company? Yes, A Limited becomes a foreign company. Why? Because two conditions have been fulfilled. It is a company incorporated outside India and has a place of business in India. Either you are having directly or through an agent like Abhinav Kumar as an agent you have appointed. He is running your business in India as well. Therefore, it becomes a foreign company. And you must be conducting any business activity in India. Say Mohammed has appointed Abhinav to do business in India, but there is no business happening in India. Then it is not a foreign company. So if you have appointed a company, incorporated a company in USA, and you don't have any place of business in India, you are not doing any business related to that company in India, then it will not be covered under foreign company. Children, foreign company is a company to which Companies Act 2013 needs to be applied. So law says we will apply Companies Act 2013 only to our own companies. भाई बाहर की कंपनीज को तो बाहर के लॉज एप्लीकेबल होंगे ना. तो जब आप बाहर जॉब करने जाएंगे, फॉरेन कंट्री में सीए बनकर जाएंगे, तो कई बार यू हैव टू डू सीपीए, एनी अदर कोर्सेज एज वेल. So whatever laws, income tax regulations are applicable to those foreign countries, you'll be following that. But in India, we will be having a Companies Act 2013 applicable only to the companies which are in India. So then government thought, what about the foreign companies? So law said, which foreign companies? They said there are certain companies which are getting incorporation outside India, but they're also doing business in India. So government thought we will count them as the foreign companies. So since this company is having a place of business in India, since you're doing business in India as well, therefore now my Companies Act will also become applicable to you and you will be considered as a foreign company. So what are the two conditions we have to remember in foreign company? Number one, the company should be incorporated outside India. So we made a company in USA and we are having a place of business in India, say in Delhi, Kolkata, kahin pe bhi aapne ek office iska khol liya. So yes, it is a foreign company. And are we doing the business? Yes, we must be doing any business activity. If it is silent, we are not doing any business, we have just opened an office, then it is not a foreign company. The condition of and has to be met. Number one, you have a business in India and you're also doing any business activity in India. Then it is considered as a foreign company. Clear? Quickly, let's move to Section 8 companies. Mark Section 8 companies. Very, 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 very important. बहुत important है. And many people are setting up companies under Section 8 companies. So I told you children last time also, under Companies Act 1956, it was known as Sameer Singh, revocation means cancellation. Let me reach till the point of revocation, then you can ask the questions, okay? Okay. So children, Section 8 companies were earlier named as Section 25 companies, and now Companies Act 2013 has given it a specific name of Section 8 companies. I'm not reading your queries. Come back, listen to me for Section 8 companies. I will definitely give you time for the queries, but please, my humble request, children, let me complete the syllabus first. We have a time constraint. I have to abide by the rules and regulations which have been set by the ICAI. We have a limited time period in which we have to complete the syllabus. After that, we will move to the queries, okay? Section 8 companies are the companies which are incorporated to promote the charitable objects. So say, for example, if you opened up a company and you thought that I really want to promote any particular kind of sports. So you are really keen of football and you want that the students and children should be given an opportunity and you want to promote that sports activity. Or maybe for some educational or research work, you have opened up a company. Or maybe for the welfare of some certain religion or certain charity purposes. So any charity kind of thing, protection of environment, where you want to protect the environment, you want to encourage people to plant the trees and you want to make them aware about not to create a pollution. So such kind of activities which are related to a society. So any company that you're creating for the society welfare or for certain charitable work, they are not considered to be on the trading purposes. They are not for commercial purposes. They are known as Section 8 companies. You are having a company. You will not call it a government company. You will not call it a public company. You will not call it a private company. You will call it Section 8 companies. So where any company for promotion of commerce, art, science, sports, education, environment, charity, religion is created, it is known as Section 8 companies. Now, since it is not on trading purposes, therefore you don't pay any dividend also to your members. Will you pay dividend? Says you will be applying your profits only for promotion of your objective. So if I have opened up a Section 8 company and I want to promote a particular kind of sport, say, for example, I want children to come forward and participate in football. So I've opened up a company and I'm working in that company to encourage the students to come and promote particular kind of sports. Then whatever profits I'm getting from that company, whatever applications have to be done, it should be for promoting my certain objective. I cannot pay any dividend to its members because it is a charitable company. No dividend is given to the members. So what we have to learn over here is, number one, the purpose. So what is the purpose of these companies? The purpose of these companies is charitable purpose. Number two, the profits have to be usage. So the profits has to be applied only for promoting its object. And number three is no dividend. You don't pay dividend in case of Section 8 companies. And number four is examples of associate Section 8 companies are FICCI, SOCHAM, National Sports Club of India, CII. Okay, all these are the examples of Section 8 companies. So can you see there is no word limited or private limited after their names. They are just the companies known as Section 8 companies, which are for the promotion of particular art, science, culture, sports, education, whatever you want to call it. Now, since it is a Section 8 company, it is not very easy to set up a Section 8 company. Central government's approval needs to be taken. So it says, how will you set up this company? Simple, central government approval for the license has to be taken. So if I want to set up that company for promoting sports, I want to encourage the students, I will be setting up an academy, I will be setting up a company that our company will be entirely working how to encourage the students to come and play football. So now I cannot just get up and get myself registered and make a company. No. If I am a Section 8 company, I have to apply to the central government, and central government will issue a license to me that, okay, fine, yes, you can open a Section 8 company. So I have to comply with all the requirements of Section 8 under Companies Act. Then only I can open up a Section 8 company. So Section 8 allows the central government to register such persons with words limited liability. Very interesting. Now, children, in Section 8 companies, do I have unlimited liability? Law says no. So the first beauty of Section 8 companies is your liability is limited. Whatever you have in the company, only company's assets will be utilized for paying off the debts. Your liability is limited to a certain extent. Point number two, without adding the words limited and private limited. So in Section 8 companies, you are not using the words limited or private limited, but yes, your liability is still limited. So you have the name National Sports Club of India. It is Section 8 company. Your liability will be limited. You have a separate corporate existence, but you are not required to use word limited or private limited. Lakshmi, Balasan, Lakshmi, I hope you're understanding. Is there any doubt you have written something? I hope you're paying attention and understanding what we're discussing right now. Okay. Kashish, I'm not reading this entire question that you have sent to me right now. Maybe please you can ask me after the class later on. Section 8 companies can be, yes, Dinesh, they can be company limited by shares or company limited by guarantee. Generally, they are companies limited by guarantee. Definitely, you're right. Okay. Yes, Kaushik Raval, Section 8 companies are like non-profit organizations. Hemang, Pushpa, that's absolutely correct. Okay, Bhumika is also correct. So they are non-profit organizations, not for the non-motive of the profits, and whatever things they are earning in their business, they will be utilizing it for promoting its object. Okay, and no dividend is to be paid to their members. Now, how we are deciding how the company has to be set up. Number one, we have to apply to the central government. If the central government will issue a license as it deems fit, means you will go to the central government, you will give all the applications. Where is the detail given? It is given on the Ministry of Corporate Affairs. You will fill up the application, you will file it with the central government, and central government will read and find that this is fine. This objective can be allowed, and it will issue a license to you that, okay, go Harleen, you can make a government company. You can make a Section 8 company. The registrar shall on application register such persons as a company under this section. So number one, limited liability. Number two, no requirement of words. Number three, license will be issued by a central government. And fourth point is, registrar is going to file shall on application register such persons. So now you will go to the registrar of companies. You will tell them, see, we have a license from central government. Please give us the tag of Section 8 companies. So he will make a entry in the register and he will record your names or association of persons who have come together that you are Section 8 companies. And point number 5, on registration, you will enjoy the same privileges as those given to a limited company. So it says, what do you become on registration? You become a limited liability company. Okay. Now comes your word of revocation. इतनी बार पढ़ चुके हो revocation का मीनिंग पूछ रहे हो children. Revocation means cancellation. So now central government is very angry. He gave you a license. So Harleen set up a company A Limited as a Section 8 company. So I was given a license from the central government. I took an approval and I said, I want to promote sports. Government was satisfied. Registrar has also entered my name as Section 8 companies. Now A Limited is a Section 8 companies and it is doing business for its purposes. But this A Limited was very bad. It tried to contravene the provisions. A Limited decided that it is Section 8 companies. We took a license from central government, but out of curiosity, out of sudden increase in profits, we started paying dividend to our members. Can A Limited pay dividend? I just taught you Section 8 companies are prohibited from payment of dividends. Now central government says, if you do any such things, if you try to act fraudulently, if you try to violate मतलब fulfill मत करना, गलत करना, आप कुछ भी violate कर रहे हो, rules and regulations से abide नहीं कर रहे हो, follow नहीं कर रहे हो. If you violate the objects of the company or you do something prejudicial to public interest, means something against the public interest. If you're doing any wrong thing, any illegal activities, then central government will cancel your license. It will revoke your license, means it will now cancel your license. It will take back the license from you. Listen now. You promised that you will not be paying dividends, or you decided you will be Section 8 companies, but now you're doing something else. You're indulging in commercial transactions. You are paying profits, dividends to your members. If any such thing, you are supplying drugs, you're doing illegal activities, you're Section 8 companies for charitable purposes, and you're violating the provisions, then central government will straight away cancel your license. This is the meaning of revocation of license, means cancellation of license. Central government can immediately cancel your license if you do any fraud, you violate the provisions, or you do something against the public interest. Now, this second paragraph, this small paragraph, deals with what will happen on this cancellation. अभी समझ आ गया cancellation कब होगी? आपने कुछ भी गलत काम करा तो आपका license cancel हो जाएगा. Now we are going to talk about from this to this line. It says on revocation, means on cancellation, registrar will add the word limited or private limited against your company's name. Now what happened? It says you were A company, say Section 8 company थे आप, अब आपका नाम बन जाएगा A Limited or A Private Limited. Your license has been cancelled. I was telling you earlier Section 8 company, so it was a ABC company which was Section 8 company. We cannot have the words limited. Okay. So ABC was Section 8 companies. Now, if you have violated any of the provisions, your license gets cancelled and the registrar will add word ABC Limited or ABC Private Limited after your name. You can still run yourself as a company, but either a public company or private limited company, you will no more be a Section 8 company. And also central government will give a written notice of its intention to revoke the license and opportunity of work. So central government एक written notice issue करेगा ABC को कि look, we have found that you are violating the provisions. Your name is going to get cancelled, and if you want, you can come and present yourself. Opportunity of being heard means we will ask him to come and represent themselves and tell us why you did so. Yes, Danish, Section 8 companies cannot give the dividend. Okay. So central government, Sameer Singh, from time to time will prescribe that limit. You don't need to worry about that. Ankit Prasad, revoke means to cancel. Yes, Mayur, that's correct. Insurance companies, Maram Sridhar, we'll talk about the insurance companies, public financial institutions. There we will clear that point. Okay. Natural person, be the owner. Akhil, company is never a natural person. Company is always an artificial person. Please remember that. Company is not a human being who has come into existence. It's an artificial person who can't be seen and touched. Okay, children, now please listen here. So revocation of license is clear. Why it gets cancelled? If you're contravening any of the provisions, what will happen when it gets cancelled? The word limited or private limited will be added, and central government will give a written notice and an opportunity to be heard. Order of ये छोटे छोटे points 1, 2, 3, 4 mark to कर लिया करो ताकि easy हो जाए learn कर. Okay, now what happens with the order of central government? Here we talked about the cancellation of the license. Here we are going to talk about the order of the central government. What kind of order he is going to give? He will revoke the license and he will pass a public order in trust in the public order. He will pass an order in the public interest that the company shall be amalgamated with another company which has similar objects. So what will central government pass an order? He will say, look, ABC, we have found that you are paying dividend to your members, which is you're violating the provisions or any XYZ reason. So now you either add the word limited or private limited, or you can amalgamate yourself with any other company which has similar objectives and you form a single company. So either you will be asked to wind up the company, means end up the company. Either he will say, ABC, you please end your work, or you can get yourself amalgamated. I hope you know the meaning of amalgamation, mergers, children. Merge yourself with another company. Amalgamation, aapne usme bhi padha hoga in your accounts. So amalgamation means you get merged with another companies which have similar objectives. So say there is another company, CDE, which is running as an Section 8 company. So government can say that CDE is another company which has same objectives of promotion of sports. So you please merge yourself with that company. That's it. Okay, so you can either end up the company or you can merge yourself with a company which has similar objects. And what is the penalty? So it says, what is the penalty? What is the punishment that is going to be given in case you contravene the provision? So here you can write about the fines and penalties to be paid. So we discussed about the cancellation in the first paragraph. We discussed what kind of order, amalgamation topic, that we can amalgamate the company with a similar objective. This is written in the order of central government. Now we're going to talk about what kind of fines or penalties we need to pay. So if any company which is doing any default, if you're not fulfilling the requirements, Section 8 company is doing any default, then a fine of 10 lakh rupees to 1 crore can be charged. Children, such a harsh fine, 10 लाख रुपए से लेकर 1 करोड़ तक की कीमत चुकानी पड़ सकती है. If you set up a Section 8 company and then you try to do any kind of violation, you try to do any kind of fraud. Yes, Sarvesh, if you're held guilty of any kind of fraud, then your license gets cancelled and even a fine can be charged of 10 lakh to 1 crore rupees. And every director and other officer who shall be in fine can also be sent for imprisonment. What is the meaning of imprisonment? Sending him to the jail. He can be imprisoned for 3 years, and also there is a limit of fine which can be imposed, a fine of rupees 25,000 and extending up till 25 lakh rupees. What you have to remember, anybody violating the provisions of Section 8 companies, number one point is a fine of 10 lakh to 1 crore rupees you have to remember shall be charged. Imprisonment for 3 years is the second point. And a fine to every directors of 25,000 to 25 lakh rupees shall be charged. Whereas these frauds given, Section 447 specifically deals with fraud. You don't have to read 447. CA Inter will be taking care of 447, but he's just trying to give you basic information. See children, what is the meaning of foundation? CA foundation. हम आपकी एक foundation ले कर रहे हैं. इसी तरह से companies की basic foundation क्या है? You simply have to understand in CA foundation that how the companies are made, how they are incorporated, what are the important documents like MOA and AOA, what are the types of companies, basic information. So he's just telling you that where it is proved that the company was fraud, every officer will be liable to a fraud given under Section 447. So अभी के लिए कितना लर्न करना है? 447 में fraud की provisions है, वो पता होनी चाहिए, but क्या provisions है? No need to learn that. But the fraud provisions given under Section 447 will become applicable. Yes, Arnab Ghosh, where you're merging with the company, all the rules and rights of the same company will become applicable to it. Okay, so these are the significant points, children. They cannot declare dividend. They have to use the profits. Minimum requirement of share capital does not apply. So there is no provision of minimum share capital. So you can set up a company with 10 lakh rupees, with 1 crore rupees. It is up to your choice. There is no requirement of minimum paid up share capital in case of a Section 8 company. How it operates, special license from central government has to be taken, and it can be a club or chamber of commerce. You don't need to use the word limited and private limited. Can the license get revoked? Yes, if you contravene the provisions, license get revoked. What happens? It converts its status or changes your name. So central government can direct you that now you become a private limited or you become a public limited company and change your name. Or the third can be, it can ask you to end up the company. Wind up करना मतलब company को end कर देना. Please आप company close कर दीजिए. So central government can either ask you to convert the company to public or private, or to end the company, or amalgamate yourself with a company having similar objective. So these kind of directions can be given in the central government's order. You can call your general meeting by giving a 14 days notice. So generally children, in the companies you have to give a 21 days notice, but section 8 has been given a special privilege that 14 days notice can be given if you want to invite everyone for the meetings. It does not need a nomination and remuneration committee, a partnership firm. Now, this is important point. Partnership firm can also be a member of Section 8 company. So I told you other day also, although partnership firm is not a separate legal existence, it is not a natural person. So partnership firm can never be a member of a company. But in Section 8, yes, a partnership firm can also be a Section 8 company's member. So if you're having ABC Associates and you're doing any business with ABC Associates under the partnership, now this ABC Associates can also be a member in Section 8 companies. So law says if you are promoting any particular object, then the firm can also become a member in Section 8 companies. Okay, so very beautifully your study material has broken down these points. Read these flowcharts, make notes, write it down in your notebooks. ये same repetition है flowchart form में जो दिया हुआ है आपको Section 8 companies का. And the last one is dormant companies. What is the meaning of dormant companies? Companies which are inactive companies. So law says any company which has been incorporated but has not been carrying any business, has not been doing any significant accounting transaction for how many periods? From 2 financial years. So कितने टाइम का टाइम दे दिया उसने? 2 financial years आपने चेक करना है. So if you opened up a company, ABC Limited company, you opened it up, you got all the registration done, you paid the fees to the registrar, you allotted the shares, you maintained the office records, but were you doing the accounting transactions? No. Were you doing the banking transactions? No. Were you doing any kind of business? No. So from last 2 financial years, if you have not done any significant accounting transactions, if you have not filed your financial statements, you are not preparing your profit and loss and balance sheets, then law will declare such company as a dormant companies. So section 455 says any companies which were incorporated from last 2 years, they are not doing any significant accounting transactions, then they are given the status of a dormant companies, means inactive companies. What is significant transactions? Anything apart from these 4 is considered as significant transactions. So law says if you are simply paying the fees to the registrar, it's okay. It doesn't mean any accounting transactions. If you are fulfilling the requirements of any other law, it doesn't mean you are doing the accounting transactions. You have to do the business in order to be an active company. If you're not doing any accounting transactions, then you'll be considered as a dormant company. And children, public financial institutions, we already discussed when we started with the chapter that Companies Act is also applicable to LIC, infrastructure development, and Unit Trust of India. All these are also having an application of public financial institutions. Companies Act is applicable to them as well. Only where there is a disagreement with the respective act, then the provisions of their respective act will become applicable. तो ये सिंपल सी डेफिनेशन पब्लिक फाइनेंशियल इंस्टीट्यूशंस की लर्न कर लेना इसमें से. व्हाट इज निधि कंपनीज? ध्यान से सुन लो, दैट इज इंपॉर्टेंट. So Nidhi companies are also known as mutual benefit societies. So children, many a times people nowadays have started encouraging the habit of savings. So people just come together and they form the funds. Say for example, A, B and C, they decided that let's contribute the funds together and let's set up a Nidhi company. Now, Nidhi companies are set up for the mutual benefit. Mutual का मतलब क्या होता है? आपसी benefit, for your benefit and my benefit. So Harleen ma'am decided to open up a Nidhi company with Sameer Singh and Mansi. So Sameer contributed 10,000, Mansi contributed 50,000, Harleen contributed 15,000. So we together formed the capital and we set up a Nidhi company. Now, whenever any one of us, 3 people, Mansi, Sameer and Harleen, they need money, They will take the contributions from that mutual funds and they will utilize it for their purposes. So it is a kind of a committee, like, जैसे हम किट्टी डालते हैं, committees करते हैं, like for a friendly basis, we are joining and encouraging the saving habits. So we try to utilize that money for our own benefit. So similarly, law government has given you an authorization to set up a Nidhi company. That is also a company status you get, and a mutual benefit society, wherein you're just encouraging the people to save their money. They deposit their money together, and as and when there is a need, they take out that money and utilize it for their specific purposes. All right, with this, we come to an end of types of companies. Let's take a small break and then we'll complete the further syllabus. Okay. All right, welcome back, students. So I've just gone through your queries. Meanwhile, Yajit Sen, you don't need to worry. He's sounding so worried. How will we revise everything? Otherwise, it is very getting clear right now. So the way you are understanding the lecture with me, later on also, the recorded lectures are there with you on the YouTube. Just go through them, listen to them once, and along with that, keep revising from your study material. You'll definitely be able to complete it. MD Razak is asking how to write the answers in law papers. So if you'll go to back to my partnership lecture, child, I have taken up a certain case study in that particular example in the lecture, and I've taught you how you have to write your answers. Even in today's session, when I'll go through the second presentation of Companies Act, I'll tell you how you have to write the descriptive case studies. You have to write the concerned provisions first, then you have to give the facts of the case, and then conclusion. Pushpa Kumari is asking me to tell me in Hindi how to write the answers. So Pushpa Kumari, आपने to the point answer लिखना है. लॉ में हम कभी भी बहुत ज्यादा कहानियां नहीं लिखते हैं. हमें जितना क्वेश्चन पूछा गया है उसी का ही रिप्लाई करना है. बट द ब्यूटी ऑफ द आंसर इज, आंसर को कैसे अच्छा बनाना है, आपने उसे पॉइंट्स में लिखना है. आपको समझाना है कि एग्जाम्पल में क्या फैक्ट्स दिए गए हैं एंड किस एनालिसिस के बेस पे आप इसको कंक्लूड कर रहे हैं. आपका क्या आंसर निकलता है उसकी रिप्रेजेंटेशन जैसे मैं 3 पॉइंट्स बताऊंगी उस तरह से करनी है. All right, children. So I hope now we are cleared with all the types of the companies, and these are my notes which are also uploaded on the ICAI portal. And yes, I know there are 2 important amendments we still have to do in the definition of listed companies, and a small change in small company. You will refer, children. I have updated that where it is written INR 50 lakhs and 2 crores is the limit, but the upper limit has now become 2 crores and 20 crores. So just change if you have the old study material. In small companies amendment which has recently come, the limit of 10 crores and 100 crores has now become 2 crores and 20 crores. Okay. And also there is another additional point. So let us quickly go through the amendments. I think I showed you the amendments in the last session also, but there were 2 important points to be discussed. So OPC, everybody is clear now. 120 days condition has to be seen. Conversion of OPC is now omitted. It is no longer there. Small company, here is written higher limit is now 2 crores and 20 crores. I just showed you in my PPT as well. Listed companies definition. Earlier, it was just giving you this much, that the company is listed on stock exchange. Now, one small important line has been added. You also have to write this line if examiner might give you a definition of listed companies for 2 marks. So it says a company where securities are listed on recognized stock exchange. Yes, ma'am, we understood that your securities should be listed. Provided means now a proviso has been added, a condition usne aur laga di, that such class of companies which have listed or intend to list such securities which are prescribed in consultation with SEBI. SEBI means Security and Exchange Board, shall not be regarded as a listed company. So he has given you a provision that where certain securities which they have decided with Securities Exchange Board that, okay, fine, they can still have listing of such kind of securities, then they might not be considered as a listed companies. So how it happens, what happens, this is in consultation with SEBI. You simply just have to remember this one-liner as a definition of listed companies. Another Section 8 companies also have a very, very important amendment with effect from 21st December 2020. So children, I just taught you about Section 8 companies, and we have discussed that there is certain fine which has to be imposed of 10 lakh rupees and 1 crore rupees, and directors will also be liable. But where it was written an imprisonment for a term of 3 years has now been omitted. So there is only a fine which has to be imposed. No imprisonment, no jail can happen for a Section 8 companies. Now, the reason for teaching you, because many of you children refer from the study material which is there online. So if I'll not teach you there, then I will not be able to explain you how the amendment happened. So it's very important to take concern of each and every student. Those who are having the latest study material will not be having this imprisonment figure. Why? Because it has been amended. But if you have an old study material, please cross this line of imprisonment in Section 8 companies. Now there is no imprisonment, only a fine of 10 lakh and 1 crore, and the other fine of 25 lakhs and 25,000 to 25 lakhs is existing. Okay. So there is still the fine of amount is there, and 1 crore fine is also there, but imprisonment is no more there. Okay. These are your amendments. So we are done with the amendments also. Now let us open the last PPT that we have to see. We are still left with certain important topics to be covered. So let's jump to them. So this is your Companies Act Part 2. So children, I have divided the Companies Act to SEBI wala Kashish, you don't have to go into much details of Securities Exchange Board. You simply have to remember the change in definition that has come. Okay, good, Jyoti. I'm glad you got it. Yes, Paras Singla, that's correct. Okay, I will not go into the queries, otherwise it will take too long. Let's first complete the syllabus, then we'll go into the queries. Okay, children, so this was the syllabus that we have discussed. Now, May 2019, few examination questions I'm going to discuss with you. All those who are asking how to write the answers in this presentation, I will clearly teach you how you have to represent the answers. So pay attention. Now, this question is exactly related to your holding and subsidiary company. It says Popular Product Limited was a company incorporated in India. Now, children, just see, for a 3 marks question, such a big story has come. But when you read the story, you will find it is so very simple. So Popular Product was a company incorporated in India and having a share capital of 20 crores. How the breakup of the share capital is given? They were having 12 lakh equity shares and 8 lakh preference shares. So Delight Product Limited, so first information they have given you, Popular Product Limited was having a share capital of 20 crores. Second information given is Delight Products and Happy Products holds 2 lakh 50 and 3 lakh 50 shares in Popular Limited. So out of this entire 20 lakhs, how much they are holding? 6 lakh shares they are holding in the Popular Product Limited. Another company, point number 3, Cheerful Product Limited is holding 2 lakh 50,000 shares. So after 6 lakhs, 8 lakh 50,000 more they are holding. Jovial Limited is the holding company. So पहले यहाँ से conclude कर लेते हैं. Delight, Happy and this Cheerful Product, they are combined holding 8 lakh 50,000 shares in the Popular Products Limited. Am I right? What is the another information? It says Jovial Limited is the holding company for all these companies. So Delight, Happy and Cheerful, they all are the subsidiary of Jovial Limited. Now come an interesting question. क्या बताया examiner ने? He himself told you that Jovial Limited is the holding company. And look at him. What is he asking you? He's saying, can we say Jovial Limited is a subsidiary company of Popular Limited? He said Jovial is the holding for 3 companies, Delight, Happy and Cheerful. Can we say Jovial Limited is a subsidiary of Popular Limited if it is controlling the board of directors of Popular Limited? So children, first of all, apply your minds and tell me that can any company be called a subsidiary company if you are holding the composition of board of directors? So quickly answer me yes or no. It says Jovial is, don't go into information which is given over and above in the question. Simply tell me, can Jovial be termed as subsidiary company if he is controlling the board of directors of Popular Limited? Yes, ma'am, or no, ma'am? Jaldi. I want the answers quickly. So can we say that Jovial Limited is the subsidiary company? Yes or no? I know you all are intelligent students and you know the answers very well. So can you just imagine 3 marks में इतनी सारी information examiner ने आपको दिया और question कितना ही simple था. And you know, at times you get so scared that you don't even bother to read what is given over there. Okay, very good. Jyoti, Vidhi, Dainesh, Priyanka Jha, you all are saying yes, ma'am. Jovial will be considered a subsidiary. Very good. Very nice. That means you're not paying attention. Your answer is absolutely wrong. Please pay attention. What happened? Okay, who else is going to tell me Jovial will be considered a subsidiary? Child, if your company is controlling the composition of board of directors, you become a holding company, not a subsidiary company. तो पहली बात तो क्वेश्चन ही आपको ध्यान से पढ़ना चाहिए that there is nothing being a subsidiary. When you are holding the composition of board of directors, then you become a holding company, not a subsidiary company. Let me teach you how you have to write the answer. So now you have to give the basic information in the present case, how we will represent. So it is a 3 marks question. We will simply tell him what is happening in this present case. Very good. All those who have written, no ma'am, Jovial Limited will become holding company. Excellent. Ratna Singh, Pragati, Ankit Mishra, MG Razak, Hira, Ranjit Singh, Chandan Kushagar, all of you are correct. Asha Babu, Rimjim, Mansi, Sangeeta Chaudhary, Ajit Vichatan, all of you are correct. Very good. Okay, Priyanka Jha, you don't need to be sorry. I know you all understand. So we don't have to take the decision in haste. We have to read it carefully. Sarthak Agarwal, very nice, correct. Himang, Sridhar, very good children. Okay, so in the present case, the total share capital is given for rupees 20 lakhs, and this is how they're holding the capital. So this is just the information. Breakup of information has been given. It has nothing to do with the question. What has to do with the question is that all these three companies are combined holding 8,50,000 shares, and Jovial is the holding company of all these three companies. Therefore, Jovial, along with its subsidiaries, hold 8,50,000 shares in Popular Limited. So are they holding more than 1/5 of the share capital? So children, total share capital is 20 lakhs. Total share capital is 20 lakhs. So for holding 50%, at least they should have been holding 10 lakhs shares. Sahi hai? But they are holding only 8,50,000. Therefore, by virtue of shareholding, it is not a holding company. So कह रहे shareholding से पता लग रहा है कि Jovial Limited is not a holding company. Secondly, it is given that now if Jovial is also controlling the board of directors, then yes, Jovial Limited will become a holding company and not a subsidiary company. Okay, so all of you who has written, if he's holding the composition of board of directors, then yes, he will become a holding company. But we will not write just this much in the exam. We have to write all of this in order to express ourselves properly and get full 3 out of 3 marks. Okay, clear hai? So these kind of examples you have to read from my PPTs and do it yourself. This is the another November 2019 exam, which we have done already earlier also. You can go through it, children. And now let's move to the filing of documents with the registrar of companies, incorporation of a company, a very, very important topic. So I told you that in CA Foundation, we are going to lay your foundation. We are understanding how the company is incorporated, how the company is made, how the company gets that legal status of separate legal entity. This is the procedure how the company is incorporated. So what we have to learn in this, ma'am, this is simply telling us the procedure of incorporation. क्या फाइल करना है, कैसे कंपनी को रजिस्टर कराना है, कैसे सर्टिफिकेट ऑफ इनकॉर्पोरेशन इशू होता है. All these detailed 1.5 page which is given in the study material tells you about what documents you need to file with the ROC. So number one thing that you have to remember over here is who is a promoter. So who is a promoter in a company? So promoter are the person who has come up with an idea of setting up a company. So if Harleen ma'am and Chandan, they have come up with an idea that let's start a business of, sale and purchase of electronic gadgets. So we will be considered as the promoters of a company because we have come up with the idea of setting up the business. So if Harleen and Chandan wants to set up a private limited company, then yes, minimum 2 members are required. So promoters will then sign the memorandums. They will make the memorandums. They'll make the articles of their company. They will sign it and they will get it filed with the registrar of companies. So who is a promoter? A promoter is a person who has come up with an idea of a business. Either the promoters themselves file with the registrar, or there will be people who are subscribing to the memorandums. And once the company is incorporated, when we take up the shares in a company, we become the shareholders. So promoter, when you're setting up of a company, you subscribe and sign the memorandum, you become subscribers to the memorandum. When the company is incorporated, you become members of the company. And when you take up shares in the company, you become shareholders. And when the shareholders appoint directors, one of you become a director of the company. So this is just a different name given to the persons who are associated with the company. So even in your study material, the definition of promoter is given, which you all must learn it. So MOA and AOA duly signed has to be filed. A declaration has to be taken by the subscribers and first directors. So these are just the briefing points that I've given you over here, children, before you start asking me each and every point from study material. So let me take you directly in the study material itself so that we can read the context from there also. And keep in mind the time also, children, we have to complete the syllabus. So more of understanding today, less of asking, okay? So this is how the company is incorporated. So this simply definition you can learn: person who are known as promoters, those who conceive the idea of forming the company. Conceive means those who have come up with the idea of setting up of a company. And they take the steps for the registration of the company in their professional capacity. Persons who are acting in their professional capacity as solicitor, banker will not be regarded as a promoter. So now if you have appointed a certain banker or a chartered accountant to help you in the filing requirements, then that person, if I am a CA, I am into practice and you come to me, ma'am, can you help me in setting up my company? So in my professional capacity, if I'm helping you, then I will not be the promoter of the company. You are only the promoters of company. एंड सेक्शन 3 क्या बता रहा है आपको? पब्लिक कंपनी सेटअप करने के लिए 7 और मोर पर्सन चाहिए, प्राइवेट कंपनी मिनिमम 2, 1 person, only 1 person can set up. Simple. Section 7 will tell you what is the procedure for setting up the company. Number 1, you have to file the documents with the registrar. Who will sign the memorandum and articles? It shall be signed by all the subscribers to the memorandum. So if you are setting up the company, you're promoter of the company, you become subscribers when you sign the MOAs and AOAs. A declaration by person who is engaged in the formation of company. So if I am a chartered accountant or any cost accountant or any company secretary in practice is helping you in setting the company, they shall give a declaration that, see, these are the people who want to set up a company and they're absolutely fine. There is nothing wrong with them. They're not fraudulent people and they're not doing any illegal activities. So we have to take a declaration from a CA or a cost accountant that, or maybe an advocate can give you a declaration that you are allowed to, we are helping them in the formation of company. And by the person named in the articles. Another declaration, so 2 declarations are required, one by a CA or a CS and second declaration by people who are named as first directors or managers of the company. They shall also give a declaration that all the rules and compliances related to registration have been complied with. हिंदी में हमने एक declaration लेनी है, कागज लेना है एक CA से या फिर आर्टिकल्स में जो बंदे डायरेक्टर का नाम है जिनका, उनसे एक हम डॉक्यूमेंट लेते हैं कि ये कंपनी ने सारे रूल्स फॉलो करे हैं. This company is not doing any fraud and they are setting up their new company and they are complying with all the provisions of Companies Act. Simple. Third declaration we have to take from each of the subscribers to the memorandum. So if Harleen ma'am and Chandan were the subscribers to memorandum, we will also give a declaration, and the persons whom we have named as first directors, they will also give a declaration. What kind of declaration? We have to give a declaration that we were not convicted for any offense. We were not guilty of any fraud in case of any company, and all the documents which we are filing are correct and complete. So all those who are involved in the formation of company should not have been put to jail. They should not have been found guilty, and all the documents should be true and complete. After that, you will give your address for the correspondence. Until your registered office is not established, you have to give some address so all the correspondence can be shared with you. So you have to give the address for the correspondence. मीन्स जहां पे आपकी बातचीत होगी उनके साथ, कौन सी एड्रेस पे चिट्ठी आनी है, कहाँ पे आपको मेल कर सकते हैं, वो एड्रेस देना बहुत जरूरी है. Particulars of all the subscribers, so all the surnames of the family members, residential address, nationality of all the people who are associated with the memorandum of the company, it has to be given. And the interest of the persons mentioned in the article. So all those people who are mentioned as first directors, their interests and name, addresses and residential address should also be given. Now, this first point number 1 is simply telling you how you have to file the documents with the registrar, all the kind of declarations and all the names and addresses of the people who are associated has to be given. Point number 2 tells you that if the registrar is satisfied that all this documentation has been done nicely, correctly, then he will issue you a certificate of incorporation. So Harleen and Chandan will go, they will say, sir, we have filed all the documents, we have taken a declaration from a CA also, here are the first directors, they have also signed the declaration, this is the address, all the documents are filed. Now registrar will go through all the documents, he will say that, okay, fine, they're setting up a company, everything is complete and true, and he will give us a certificate of incorporation. And also a CIN number is given to each and every company, a corporate identity number is given. This is a distinct number which makes you different company from other companies. So distinctive number is allotted and it will also be included in your certificate. Now, what we have to do, people who have set up a company, they have required to keep all these documentations and information at their registered office. So we have to maintain these copies of all the documents and we have to keep these copies at our registered office. Now, these 3 paragraphs are very, very important. This tell you, like in Section 8 companies, you were doing a fraud, a fine was charged. Here, if you are setting up a company and you give any false or incorrect information, so children, I told you, fraud and actions under 447 will be taken. So if any person gives any false and incorrect information, he is aware of the documents that we are filing are not correct, then he shall be liable for the fraud which is given under section 447. Company already incorporated by furnishing any false data or by suppressing any material fact post incorporation. So here at the time of incorporation, if you are doing any cheating, a fraud will be liable under 447. Or maybe you got yourself registered, everything was true and fair, and later on you started supplying drugs. So you're doing something fraudulent, you're hiding the material facts, your company is not good, your company is suppressing the information. Suppressing means chupana. Koi material information which is very important to be informed to the registrar and you're hiding that information, then law says these are known as post-incorporation frauds. Here, all the people who are named as directors, your first directors, promoters, everybody who is giving a declaration will be held liable under section 447. So not only just the company, even the CA who is associated with you, even the cost accountants who are associated with you who gave the declaration, all the promoters, all the first directors will be liable for action under section 447. And what will happen if you have incorporated such a company by giving false information? So all these 3 paragraph 5, 6, 7, they deal with false information. So number 1, you gave false information at the time of incorporation, 447 lag jayega. After incorporation, you started doing fraud. All the promoters, first directors will be liable for 447. What will happen? Order of tribunal. So it says in case of companies, national company law tribunals, these are the courts, specific courts which deal with the company law matters. So NCTLB, the National Company Law Tribunals, they are set up to be associated to deal with any legal matters of the companies. So now tribunal will pass an order. Tribunal will say you are giving a false information while incorporating a company. So now tribunal will make an application and will pass the following orders. What orders tribunal is going to pass? Let us read that. Tribunal will pass the orders for regulation and management, including the changes in the memorandum and articles. So he will say that something in public interest is not happening. So please change your memorandum and articles of the company. He can also make the liability of the members unlimited, or he will remove the name of the company from the registrar of companies. वो कह देगा इस company का नाम काट दिया जाए, or he will pass an order for winding up of the company, or such orders as it deemed fit. Whatever he feels comfortable, he will pass such kind of orders. So you simply have to learn that if company is giving any false or fraudulent information while setting up a new company, then tribunal has a right to pass these 5, 6 kind of orders. Any one order can be passed and company can also be asked to get closed. However, an opportunity of being heard shall be given to the company before such orders are passed. And this is again a very, very important amendment, a very important line that has come up. It says simplified pro forma for incorporating the company electronically. So nowadays, children, you don't have to physically go to the house of the registrar and file the application. You can simply jump into the website of MCAs, that is Ministry of Corporate Affairs website pe jaiye. Aaj jaakar dekhna. Open the website of MCAs, try to find out where is the SPICE form given. So there is a form which is known as SPICE form. So now law has simplified the process of filing the forms for incorporation. You simply have to go, you have a simplified pro forma. SPICE means simplified pro forma for incorporating the companies electronically. You don't have to physically go to the registrar. You simply fill the forms online and you file your copy of application. And registrar will send you a certificate of incorporation. Now, section 9 is a replication of all the characteristics of company that we discussed on the very first day. So, effect of registration means once the company gets registered, number 1, it becomes a separate legal entity. Number 2, it has a perpetual succession. It continues to exist. Company gets its own name, it has its own property, it has the power to acquire and hold the property, and the company can contract on its own, and company can sue and be sued in its own name. So if Reliance is company, if Reliance is not doing well, not paying to the suppliers, so suppliers will not go and file a case against the owners of Reliance. They will file a case against the company Reliance. Reliance in itself can also file a case against any other outsiders. So Tata Steel is not doing anything. Tata Steel has the company can file a case in the name of Tata Steel also. Shareholders can file a case. So company has its separate distinct entity. We can even file the case by the name of company. So all these respective case laws, children, that they are given over here. Now, when you're reading the study material, you just jump up to the conclusion, ma'am, Harinagar Junjun wala exam में ये case law तो नहीं आ जाएगा. अरे बेटा पढ़ो तो सही, वहां लिखा क्या है? Such a simple language. It says from the date of incorporation mentioned in the certificate, company becomes a legal person. Yes, ma'am, we know that company becomes a legal person. Do you know that it comes into existence? Company is different from its members. Yes, ma'am, it is different from its members. So Junjunwala case simply tells you that company has a perpetual existence until it is dissolved by liquidation or its name is struck off from the register. Simple. That means if all the shareholders of the company have also died, still the company continues to exist. You need to dissolve the company by liquidation. What is liquidation? How dissolution happens? See enter. अभी क्या समझना है? जब तक कंपनी का नाम नहीं काट दिया जाता रजिस्ट्रार ऑफ कंपनी से, तब तक कंपनी जिंदा रहती है. कंपनी कंटिन्यूज टू एग्जिस्ट unless it is dissolved by liquidation or its name is struck from the registrar. Simple thing is mentioned in the case of Junjunwala. And another thing they have mentioned, that the shareholders does not buy any interest in the property of the company. What does it mean? Company's property is separate from the property of the shareholders. So the conclusion of a Junjunwala case is property of company is separate from property of shareholders. Remember Mokara case? We discussed this in Mokara's case also, that property of if the timber was insured in the name of Mokara, therefore the company could not get the insurance because property of the company is separate from the property of the shareholders. Clear ho gaya? Similarly, just give a fair reading to all these case laws. They are only telling you that the company has a separate legal existence. It is separate and distinct from its members. In Spencer Company Limited also, it was held that even if company purchases all the shares of another company, it will not put an end to the corporate character. बड़ी important बात है. कहते हैं अगर holding company and subsidiary company भी है ना, then also subsidiary company will still be a separate legal existence. Subsidiary company will not become an agent of the holding company. It still has its separate legal existence. And heavy electrical में same बात उसने बोली है कि even if all the shares are held by the President of India or by the central government, then also it will not make any difference in the registered company. It still continues to have its separate legal existence and it does not become an agent of the government. So if government is holding 100% of the shares of ABC Limited still has a separate corporate existence. It is, although it will be a government company, but it still has its separate legal existence. It will not be an agent of the government. Okay, all these case laws simply write down. They are related to company's distinctive identity. Now we come to the most important topics, children. And don't worry, I will not go anywhere unless and until we have completed the syllabus. So memorandum and articles, I have already told you about memorandum and articles. This classification of capital is very, very simple, children. Nominal and authorized share capital, you simply have to remember this is the maximum amount of share capital of the company. So if we have decided that we want to set up a company, then we have to set up a maximum figure up till which we can raise the share capital. Now, this is your accounts topic also. You have learned authorized capital is the nominal capital. It is the maximum amount which you can ask the public to raise. But it is not always easy to raise the entire capital that you have decided. We always have an issued capital, means the company that capital that is issued from time to time. So say, for example, if you have decided the maximum limit of 10 crores that I want to do a business with 10 crore, then this maximum limit will be my authorized capital. And say, for example, if I've just issued to the public 6 crore rupees. So I'm inviting the application I have raised for the subscription. I have invited that 6 crore capital is decided to be the issued capital. So Schedule 3 of the Companies Act must mention the capital which you have the issued capital in your balance sheet. But what is the real capital that you have to see if you want to make an investment? That is the paid up capital. So I'll make you reach there also. 10 crore is your authorized capital, and then issued capital is 6 crore. Let's assume that public has subscribed to 4 crores only. So you have decided to raise money up till 10 crore. The maximum amount is the authorized capital. However, the company just issued it for 6 crores and subscribed is the capital which has been subscribed by the members. So they have just subscribed up till rupees 4 crores. This is how authorized, issued and subscribed takes place. So now there is called up capital. This is the capital which has been called up for the payment. Total amount called up on the shares. You remember in account share application, allotment is made, then you have first call, second call. So called up capital is the capital which has been called up. So say out of 4 crore subscribed capital, the called up capital only was 3 crore rupees. So we have 30 lakhs shares. So we had 30 lakhs shares and the called up money that we had was rupees 10 per share. But the company thought, okay, let's invite the applications only for rupees 10. So the called up will become 30 lakhs into 10. That is, this is the only amount that we are inviting. We are inviting the public to call upon the shares. So calls were sent for rupees 8 per share. However, the public only amount paid or credited. Say, for example, if they only paid for rupees 6 per share. So now this will become my paid up capital. So paid up capital is simply the called up amount less calls in arrears. So rupees 2 per share would be the call in arrears. So whatever amount is the paid up capital, that will become my final paid up capital of the company. So now what will be my paid up capital? So it says 30 lakhs, 10 rupees per share. So 3 crore was the limit. However, they only paid up for rupees 8 per share. So 2.4 crores was my called up capital. However, they only paid up the capital for 1.8 crores. So the only my paid up capital was 1.8 crore because people have only subscribed to the shares and paid up for the capital of rupees 6 per share. So now if you have to make an investment in a company, which is the capital that you will see? Will you see authorized capital? Authorized to bahut badi thi, maximum amount at 10 crore. Will you see the subscribed capital? No, we will always see how much capital has been paid up. So 1.8 crore is the paid up capital. And on the basis of this, we decide and take a decision if we want to invest in any of the companies. What are shares? Shares is the interest of the shareholders, the amount part of the total capital. So whatever amount you are investing in a company, whatever hissa that you have taken in the share capital of the company, that is known as a share. So share are of two types, children. It is equity share capital and preference share capital. First, let us do the preference share capital. So preference share capitals are very, very simple. It says preference. The meaning preference itself tell you that we are the shareholders which get the preference for the payment of dividend and also at the time of repayment. So whenever my funds, if I am equity shareholder and preference shareholder in a company, so always preference is given for the payment of dividend. Even if the company is having lesser profits, first we pay the dividend to the preference shareholders, then we try to make the payment to the equity shareholders. And second place where they get a preference is for the repayment of the capital. If the company is winding up, the company is closing, then first preference shareholders are repaid back their money. And now comes your differential voting rights. Equity share capital is divided into two categories, voting rights and differential voting rights. So simply, children, you have to remember, generally the equity shares carry one voting right for one share held. So if I have a one share in a company, so I have a one voting right. But differential voting rights has more dividend, but a different voting rights. That means you have to say, for example, you have to hold 10 shares in order to get the single voting right. So if you want to get one voting right, 10 shares were required to be held. This is what happened in Tata Motors in 2008 also. But the only benefit was additional 5 percentage points dividend is given. So we say higher the risk, higher the profits. So differential voting rights carry higher risk and higher profits. So you have to hold 10 shares in the company in order to get one single right. This was happened in the case of Tata Motors in 2008, where they have issued A equity shares, and these shares, every 10 shares were having one voting right. But the preference dividend that was given to them was 5% more dividend was given than to the ordinary shareholders. So what we have to remember in this, ma'am, we simply have to remember two broad categories of share capital, equity share capital, preference share capital. Preference shareholders are those who get the preference for the payment of dividend and repayment of capital. Equity shareholders have single voting right, ordinary shareholders, differential voting rights. I just explained you DVRs are those where you need to hold 5 or 6, maybe any kind of whatever the company decides. In this example, 10 shares if you're holding, then you get 1 voting right, but the only benefit is you get additional dividend for this. So memorandum of association, when we started with the chapter, I already told you what is a memorandum. Memorandum is the charter of the company. It is the major document which tells you how the company is going to function. All right. So children, we have very, very important case laws to be discussed in memorandum and articles of association. So I told you memorandum has a name clause, object clause. ये सारे मैंने आपको पहले दिन जब हमने डिस्कस करा था चैप्टर तो मैंने आपको हिंट दे दिया था कि these are the documents and clauses which are mentioned in the memorandum of company. So tomorrow Harleen and A, B, C, say for example, A, B, C want to open up a company. They will first make the memorandum MOA of the company. They will write, this will be the name of the company. These are following exceptions which are given, which you should not include when you're setting up a company. Section 8 companies can be having the name which is including foundation forum. So all these simple points you have to remember. And if you're setting a public company, add the word limited. If you're setting up a private limited, add the word private limited. And in case of an OPC, children, what do you have to add? You have to add the word OPC after P. Registered office clause will tell you where your office is situated. Object clause is the most important clause and the most important part of your memorandum of association. Object clause basically tells you for what purpose the company is formed. So say for example, if anything is done outside the object clause of the company, it is known as ultra vires the memorandum. So how it happens, we will understand in the Ashbury railway carriage case. Liability clause, company limited by shares, by guarantee. Now you all know company can be limited by shares, guarantee, or it can be an unlimited company. So whatever is your company, limited, how it is limited, you have to mention it in the liability clause. Capital clause, it always mentions the maximum amount of capital that you can raise. A company not having a share capital will not have this clause. So only the company which is having a share capital needs to have a capital clause also in the memorandum of association. And association clause will always talk about all the subscribers to the memorandum. They should have taken at least 1 share in the company, and number of shares taken by them needs to be mentioned in the association clause. And again, this line is very, very important. If I ask my students in case of OPC, do you need to have an additional clause? Yes, ma'am. In case of OPC, we also need to mention the name of the nominee, because name of nominee in case of death of the subscribers to memorandum, then who becomes the member? Nominee becomes the member. Then name of such person should also be named in the memorandum of association. ये सारी बातें हम कर चुके हैं, पहले डिस्कस कर चुके हैं, so don't worry. Minor cannot be a signatory, like minor cannot be a nominee also, minor cannot open OPC also, minor cannot be a signatory in memorandum also. Why? Because he is not competent to enter into a contract. समझ गए? Doctrine of ultra vires. First of all, doctrine means a principle. Any kind of doctrine. Now we have 3 principles coming up. Doctrine of ultra vires, doctrine of constructive notice, and doctrine of indoor management. So law says any kind of activities which are done outside the memorandum, the company will not be held liable for that. Simple. It says memorandum is a public document and it is open for public inspection. Anyone who is dealing with my company, you should read my object clause. Then only you should enter into transactions with my company. If you sign any contract with my company, which is ultra vires means the contract which is outside my object clause, then company is not responsible. ये आपकी गलती है. आपको मेरे साथ कॉन्ट्रैक्ट करने से पहले मेरा MOA पढ़कर आना चाहिए था. Same thing happened in the Ashbury railway carriage versus Rich. So what happened in this respective case law was, children, there was a company which was engaged in the manufacturing, selling of railway carriages. ठीक है, रेलवे कैरेजेस ट्रेन के डब्बे बनाती थी, रेलवे कैरेजेस एंड वेगन्स मेक एंड सेल करती थी, एंड दे वर आल्सो कैरिंग ऑन द बिजनेस ऑफ मैकेनिकल इंजीनियर्स. So इस तरह से related objective था company का. You don't have to learn the entire case law, children. Those who are asking me, you simply have to understand. And time is very less. Please don't bother me with your queries. Let me complete, then you can ask me, okay? Because I don't want the syllabus to be left. Next time we have to ask for an additional class because if I have to answer the queries, the syllabus goes beyond. Okay. So main object of the company is to sell and make the railway carriages. However, the directors of the company entered into a contract with Mr. Rich. So there was Mr. Rich and directors of the company entered into a contract for financing of the construction of railway line. So the company was already into manufacturing of the railway carriages, but here they are signing a contract with Mr. Rich that, okay, we will be signing a contract for financing the construction of the railway line. So there was a railway line which was to be constructed in Belgium and Rich said, can you do that? The company said, okay, we will finance you. And company ratified this act by passing a special resolution. So they thought, although it is not there in our object clause, we will pass a special resolution, and ratify means accept. What is the meaning of ratify? Means they accepted or they changed this act, they accepted this act by passing a special resolution. Company repudiated the contract being ultra-vires. Later on, company said, this is ultra-vires, we cannot do this. Rich got very angry, he filed an action for the damages. So law held later on that any contract made with the company, which is ultra-vires, cannot be ratified even by majority of the shareholders. Rich said you have a dealing of general contractors, then obviously you can do my financing also. But they were held, this is not the main business of the company. The main business of the company has to be seen very carefully. We are not into fire or marine insurance. We are not providing anything related to that. General contract was not interpreted in the very same way. Rich ne bola that you have the objective of general contractors, then obviously you can do financing. So in the law, it was held that you have to read the object clause very carefully. Here we are only in the business of mechanical engineers only. We are only sending and hiring the railway carriages. We are never into the financing of this thing. So therefore, company was held not to be liable. And it was concluded that any act which is ultra-vire can never be binding on the company, means company will not be held liable. So all these 4 points give a summary of the entire discussion and story that I've told you. When an act is performed, though it is legal, but it is not authorized by the object clause, it is ultra-vires the company and hence null and void. So जो Ashbury railway carriage versus Rich में जो case हुआ था financing of construction line, since it was outside the object clause of the memorandum, therefore that act was considered as ultra-vires and it was held to be null and void. Means it has no meaning in the eyes of law. An act which is ultra-vires cannot be ratified even by the unanimous consent. So even if all the shareholders come together and they say that we'll sign and pass the shareholders, it says that it cannot be done. Anything which intra-vires, something which is ultra-vires the directors but intra-vires the company, that can be ratified, means something which is still not beyond the powers of the company, that can still be ratified. But once you try to step outside the object clause of the memorandum, it cannot be accepted. All right. Similarly, Articles of Association says that doctrine of constructive notice was laid down on the basis of same case law. So children, these are very basic points of Articles of Association, how the articles are made, how the regulations are included. What is the meaning of Articles of Association? All the rules and regulations of the company are mentioned in the articles. Like memorandum tells you what is my name clause, what is my office clause, what is my objective. Articles tell you what are the rules and regulations of the company, how the company is running, how the company is doing the business, how directors are to be appointed, how resolutions needs to be passed. Everything is written in the articles of the company. So we can say that they are the bylaws of the company according to which directors and other officers are performing their functions. So basically, children, you can write down Articles of Association tells you about the management of the company and its accounts and audit. Okay, Section 5 is giving you the content and models of articles, what kind of regulations have to be included, certain provisions for entrenchment. Those who are asking me the meaning of entrenchment, entrenchment means certain restrictions. Entrenchment means certain restrictions. So you can restrict your articles. You can provide certain restrictions that only specific shareholders can pass a resolution, or maybe a special resolution is required for certain acts. So is tarah ki restrictions can be provided in the Articles of Association. Now, important topic over here is difference between memorandum and articles. You must do this difference. Objective. What is the difference between the objective? Memorandum tells you the basic purpose of the company. Articles tells you the rules and regulations. Simple. Relationship. Memorandum is forming the relationship of the company with outside world. Articles is defining the relationship of the company with its members. So articles is in-house. जैसे आपका घर है, you have a building. So your building will tell the post office people that this is the address, you have to send the letter here. But how you are dealing with the family members inside that house, that is the relationship of members and the company. So articles. So inside the house, what we are doing, how we are managing is articles of association. How we are going outside of a house and dealing with other members, that is known as memorandum of association. ये लाइटर नोट पे बताया आपको, ठीक है. Alteration means changes. Memorandum can be altered only under special circumstances and in the manner provided in the Companies Act. Permission of regional director is required. It is not very easy to alter memorandum of association if you want to make any change. Say, for example, I was into shoe business. Now I want to set up an electronic business. So if I'm changing my business, it's a very big decision. So I have to take the permission of regional director or maybe the tribunal in order to change my memorandum. Do you think, children, I need to change my memorandum? Obviously, I need to change the object clause. Earlier, my objective was in the shoe business. Now I need to make the changes that I want to into electronic business. So I need to change my memorandum. And any act done beyond the scope of memorandum is ultra-vires, cannot be ratified. However, any act which ultra-vires the articles can still be ratified. Something should be within the provisions of the company. If you go outside the memorandum, it is ultra-vires, null and void. But if you're still within the articles, if you have ultra-vires the articles, but you're still not crossing the memorandum limit, then it can still be ratified. Ratified means it can be accepted by passing a special resolution of shareholders. Now, doctrine of constructive notice, फटाफट से simple language में लिख दो. Doctrine of constructive notice tells you that memorandum of association and articles of association are the public documents. Doctrine of constructive notice simply tells you that MOA and AOA, memorandum and articles, are the public documents and they should be kept open for public inspection. Anyone who is dealing with the company should read these documents. Anyone who is dealing with the company is assumed to have read these documents. Children, we are not allowed to share our personal details. Otherwise, I would have loved to share my email ID for the queries. I don't mind. But never mind, if you still have any queries unanswered, try to reach the ICAI. I'll try to find out a way how I can reach back to you. Okay? All right. I'm glad you're paying full attention. Don't worry. We have another important case law, but ho jayega. Tension nahi leni. Okay. So doctrine of constructive notice sabko samajh aa gaya means it simply tells you MOA and AO are the public documents and they should be open for inspection. Any person who is dealing with the company is presumed to have read the contents of the documents. So basically, constructive notice is giving a protection to the company. Why? Because anything you deal with me and my company is not bound to do that, then it is your mistake. So you can simply write down doctrine of constructive notice and doctrine of ultra vires provide a protection to the company from the shareholders. A protection is given to the company that company cannot buy because you cannot enter into any contract beyond the powers of the company. So anybody who is dealing with a company should know that what is the power of the company. Say, for example, I'm into shoe business and you came to me and you told me that, ma'am, we'll pay you 10 crore. Can you do financing for us? So I said, I got tempted. Okay, I'll give me 10 crores. I'll do it. Then it is your fault. Tomorrow I will say, court will say this contract is null and void. She was into shoe business, manufacturing of shoe business. There was nothing related to financing. So I will hold you liable. I will tell in the court that they should have read my object clause. So law said these kind of things were happening. Protection was given to the company. But don't you think something which is happening inside the company, outsiders are not bound to know that? So protection was given to the company by doctrine of ultra vires and doctrine of constructive notice. Constructive notice means notice है, हम ये मान लेते हैं कि जब मेरा मेमोरेंडम एंड आर्टिकल्स पे ठप्पा लग गया, रजिस्ट्रार ऑफ कंपनीज के पास वो चले गए हैं, वो पब्लिक डॉक्यूमेंट्स बन गए हैं, दे आर विजिबल टू एवरीवन, सो इट इज रिक्वायर्ड दैट एवरीवन हु इज कमिंग टू डील विद माय कंपनी दे शुड हैव रेड दीस डॉक्यूमेंट्स. But now, ma'am, how come doctrine of indoor management came into existence? So children, law said something which you are doing inside the company. The doors of the company are closed and something which is happening behind the doors of the company, outsiders are not bound to held liable for that. How do I know what are you doing inside the company? Okay, fine. You said, ma'am, read my memorandum. I read your memorandum. I accept my mistake. You were into manufacturing of railway wagons. I did financing. Okay, that is fine. Doctrine of ultra vires got applied. Similarly, constructive notice. I have to read the memorandum. I read my memorandum. You are into shoe business. I made a contract with you for shoe business. समझ आ गया. अब indoor management क्या है? There were certain rules and regulations which I am doing inside my company. Indoor management says doctrine of constructive notice in no sense means that you are supposed to have the notice of the internal affairs of the company. An outsider is only required to know all the detailed formalities, only the memorandum. But if company in itself is doing certain changes, say for example, there is borrowing powers of the directors. If they don't have this much borrowing powers, say they can only borrow up till 10,000. So I have passed a resolution in my company that directors can only borrow up till 10,000. My directors went out and they borrowed 15,000. Now it says, how will you deal in such kind of situation? So outsiders also needed a protection. Company cannot always be protected. So where you have written doctrine of ultra vires and doctrine of constructive notice provides a protection to company, please write down doctrine of indoor management provides a protection to the outsiders who are dealing with the company. Doctrine of indoor management provides a protection to the outsiders who are dealing with the company. So what happened in this particular case now was, children, there was Mr. Turkwan who was the official liquidator of the company. So what was the company? This is the name of company, Steel Coal Logger Railway Company. एक company थी जिसका liquidator था Turkwan. Now what happened? This Turkwan had a fight with Royal British Bank. Okay, so there was a company who's a liquidator. So company is not filing a case. Liquidator filed a case for the Royal British Bank, filed a case against this liquidator. They said, Royal British Bank said that we had given a bond of £2,000 to Royal British Bank, which was secured the company's drawings on their current account. So you can simply write down in your own words, a loan amount was given. So Royal British Bank has given a loan to the company. A bond was raised for £2,000. And this bond was under the company's seal. What is company's seal? ठप्पा लगा हुआ था. तो company की seal से था. 2 directors and company secretary ने sign भी करा हुआ था. But when the company was sued, it was held that the articles directors had only power to borrow up till a particular amount. A resolution has been passed, but not specifying how much the amount directors could borrow. Now, very interesting. Royal British Bank went to the court and they said, Royal British Bank said, see, this company has borrowed a loan, they have issued a bond of £2,000 and now they're not repaying the money. The bond was issued under company's seal. But the company said, Quant said, the official liquidator, who was the official liquidator of the company, he filed a case. He said, no, company is not liable. You know why company is not liable? Because we had to pass a resolution. We have not authorized the directors for this much amount. Royal British Bank said, how do I know whether you are authorizing the shareholders or not? I am simply bound to know that you have the power to borrow and you borrowed it. So in this contentions, in this fight, law held that Royal British Bank will win the case. Why? Because directors can borrow only up till the certain amount. Whether your resolutions have been passed or not, there was a constructive notice. You have informed me that directors have the power to borrow the amount. Now, anything which is happening in your internal workings, outsiders are not bound to peep inside and check whether you have fulfilled your internal workings or not. So simply you have to remember in this case law was that even if internal shareholders have not passed the resolutions, you have to provide a protection to the outsiders. If your company is at fault, you cannot hold the outsiders liable for that. So in this case, Royal British Bank won the case on the basis that there was a provision that the directors could borrow the amount. How much amount was authorized? It has to be informed. If an ordinary resolution has been passed, it will be assumed that the directors had the power. So there is an indoor management. Companies' indoor affairs are the company's problem. I really like this line a lot. वो कह रहे हैं कंपनी का जो अंदर हो रहा है ना इंडोर मैनेजमेंट इंडोर अफेयर्स वो आपकी प्रॉब्लम है आउटसाइडर्स की प्रॉब्लम नहीं है. सो हमने 3 चीजें सीख ली. डॉक्ट्रिन ऑफ अल्ट्रा वायर्स प्रोटेक्ट कंपनी. डॉक्ट्रिन ऑफ कंस्ट्रक्टिव नोटिस विल प्रोटेक्ट द कंपनी. डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट विल provide a protection to the outsiders. Okay. All right. Now let's go to the exceptions of the indoor management. So the best part in law is whenever we make a rule, we always try to give you the exceptions. कुछ नहीं है बस 3 exceptions रहेंगी खत्म होने वाला. So indoor management को ये भी कहा जाता है Turkman rule भी कहा जाता है doctrine of indoor management. Now children, again the exceptions has been given means it's not always easy to hold the company liable. Still, certain exceptions are given to the case of doctrine of indoor management. The first exception is constructive knowledge of irregularity. Now, this is very, very interesting. If you read these simple cases, it says where the director is a person who knows that I don't have the power to raise a loan beyond a certain limit. So there was a director, Mr. A, he was an insider as well as an outsider of the company. So Mr. A was a director in a company ABC Limited and he knew that the company can only give a loan of rupees 1,000. But he himself borrowed a loan of rupees 10,000 from the company. Now he was in the knowledge of irregularity. Don't you think he was aware? Yes, ma'am, he was a director. He was aware that the company's borrowing powers is not beyond 1,000, but he himself is borrowing a loan of 10,000. In such a cases, doctrine of indoor management will not be applicable and this respective director will be held liable. It says it will not provide any protection to the person who is dealing with the company and has the notice of any such irregularity. So this director is already a person who is dealing with the company and he is aware of the irregular transactions that is doing. In such a case, this particular director will be held liable. Similarly, Turkman rule is not applicable if there is any suspicion of irregularity. Now, this is again Anand Bihari Lal is very, very interesting case law versus Dinshaw and Company. वो कहते हैं यहाँ पे क्या हुआ था in this case law, a person who was an accountant in a company was trying to transfer the company's property. So you came to my company and I am an accountant of a company and I said I want to sell the company's property. Don't you feel that there is a suspicion? Don't you have a doubt? Law says obviously in case of such conditions you must have a suspicion is raised that how can an accountant sell the company's property? He's just an accountant of the company. So in such a case, the transfer was held void. Something which is outside the scope of your authority. Here, you cannot hold the outsiders responsible. Here, this particular accountant needs to be held liable. Why? Because in the absence of any power of attorney, accountant has no authority to sell. How can he sell the company's property? Anyways, company's property is different. Shareholders are different. And here, this accountant, without the power of attorney, he's signing a contract of selling the property of the company. So ऐसे मजेदार केस लॉ इसमें दिए हुए हैं. वो कहते हैं डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट यू कैन नॉट होल्ड द आउटसाइडर लाइबल. इन दिस केस दिस आनंद बिहारी लाल विल बी हेल्ड लाइबल बिकॉज द अकाउंटेंट हैज नो पावर टू सेल द प्रॉपर्टी ऑफ द कंपनी. And the last interesting case law, which is the examiner's favorite as well, and many a time children question comes on the basis of Ruben versus Great Fingal Consolidated. You don't need to learn the name of the case law. So Turkman rule is not applicable to the cases of forgery. Forgery means giving any kind of fake signatures. So if I make any contract with the company and I give the signatures of directors and I try to do the fake signatures of company secretary, in such a case that particular company secretary who is forging the signatures will be held liable and outsiders will not be held liable. So again, doctrine of indoor management tries to provide a protection to the outsiders. It says in case of any forgery, any fake kind of signatures, your forged means fake. Irregularities. If you are having any irregularity, you have the notice that the company is doing, director is doing something wrong, then that director will be held liable. If there is any suspicion about the irregularity, then that respective person, the accountant in our example, will be held liable. And if any company secretary is trying to do a fake signatures, Turkman rule will not be applicable. In such a case, company and that company secretary will be held liable. All right, children. So I'm glad we are still okay with the time period. And with this, we come to an end of today's session also. I hope you have enjoyed listening to the sessions. You have been marking your points, even if it was little on Shatabdi Express speed that I have used today, because I really wanted to complete the syllabus, children. So don't worry. Listen to the recorded lecture carefully. Do a pause, make your notes, keep it writing it down. I'm sure you will be able to complete your syllabus well in time. All right. So as promised, let me just take up few relevant. Thank you, Mansi Kumari. Thank you, Kashish. Thank you, all of you. Thank you, Dhairya Verma. I'm glad. I'll just take up certain relevant queries before winding up the case. Ratified means you cannot make it accepted. ठीक है, मैंने लिखवाया था आपको मैंने. Okay, equity shareholders. Yes, you can say that, Mr. Abdul. Okay, somebody's asking tribunal, Sanket. Mr. Sanket, tribunal is a kind of court which is set up to National Company Law Tribunal is a kind of a court which is set up to deal with the company law matters. So in income tax, we have ITAT, Income Tax Appellate Tribunal. For companies, we have different tribunals. So simply you can remember tribunal is a kind of a court which is set up for the company matters. Thank you, Hemant, Vidhi. Thank you so much, Dinesh. So somebody is still sailing between partnership, children. Yes, thank you, Jyoti Jai. Even I'm going to miss you. Thank you so much, Nikhil. Thank you, Sangeeta Chaudhary. I'll try to find out if we can just open partnership once if you have certain doubts and queries. Somebody is still asking about those queries. Manisha and Dinesh are still sailing between partnership. So those who are asking about section 29, children, you simply have to remember where any interest is being sub partnership hum kar chuke hai 2-3 bari pehle bhi. You simply have to remember the particular example that is given over here. During the continuation of partnership, the transferee to whom the percentage of share has been given, he cannot interfere in the conduct of the business. He cannot inspect the accounts. And in case the company, in case the person who is transferring, that partner dies or dissolution happen or that partner is retiring, then he get entitled to all the share of the original partners, and also he can now inspect the accounts. Okay. And somebody was asking about section 19, children, and simply talks about the implied authority of the partner. You simply have to remember in this one that where are the acts on which restrictions are imposed. So although implied authority of the partner acts as an agent, but the further restrictions would have been given on the implied authority of the partner. I hope when you'll revise it, you will get to know Manisha and Dinesh. I hope you have understood. Thank you, Miss Misha. I'm glad all the concepts have been understood. Thank you, Chandan. Thank you, Priyanka. Definitely, I'll try to do that as well. Kaushik Raval, not to worry. There's still other ways. Don't worry about that. Kushagar, Ankit, I'm glad you all will study well, and definitely you will be able to clear your exams soon. Asha Babu, you simply have to understand where there's subsections written, you can read it. It is not mandatory to write the section. So clauses, subsections, likhne hai, nahi likhne hai, not important. MCQs, yes, definitely the MCQs that have been uploaded on the website portal, you can see that. Thank you, Hira. Thank you, Muhammad Ali. Thank you, Dinesh, Dipanshi. Thank you so much, children. Thank you, Bhumika. Thank you, Abdul. Abdul is still landing between LLP. So I taught you about companies. You can ask me in companies. Sridhar, we'll try to do that. Thank you, Karma. Thank you, Pragati. अंकित प्रसाद, टर्कमैन रूल हिंदी में बता दो. तो बच्चा पूरा रूल तो नहीं समझाऊंगी, सिंपल हिंदी में दोबारा नहीं समझा पाऊंगी, टाइम नहीं है ना इतना, बिकॉज यू हैव अनदर क्लास ऑल्सो. सो टर्कमैन रूल यू सिंपली हैव टू रिमेंबर दैट अगर हमेशा कंपनी को प्रोटेक्शन नहीं मिल सकती है, अगर कंपनी के इंटरनल अफेयर्स में प्रॉब्लम है, तब आउटसाइडर्स को प्रोटेक्ट करा जाता है. कंपनी विल बी हेल्ड लायबल इन दोज केसेस. ओके, थैंक यू प्रागति, धैर्या वर्मा. हैप्पी बर्थडे मोहित अरोड़ा. Good to know it's your birthday today. Thank you, Sarvesh. Thank you, Mayur. Easy way to learn, Miss Ganga. The best and easy way to learn is revise everything from your study material, go through all the things, and just keep revising and keep making your notes. So I've been telling you, make notes with the colored pens, everything you have to do. The only thing is you have to revise the context. भूलना नहीं है, तो उसके लिए याद रखने के लिए revise करना बहुत जरूरी है. Thank you, Ranjit Singh. Thank you, Lakshmi. Even I'm going to miss all of you. Weightage of this chapter, Barna, Companies Act generally come for 13 to 15 marks. So from last 3-4 papers, 13 marks question has been coming. And if you'll see in my PPT, I've also uploaded all the amendments and omissions have been given. So you can take care from that as well. All right. Thank you, children. Thank you so much. Yes, Mr. Abdul, that's clear. All right, children. So I hope you're just sharing your personal thank you notes with me now. No more queries. So definitely Chandan Shah and Pranab and all those who are writing, we can get a chance to meet you, Kaushik Raval. Even I really look forward to meet you all once in lifetime. Definitely, I look forward to see you all also as well. So thank you so much, children. It was really wonderful teaching all of you, and I really enjoyed the sessions by making it interactive and having your queries coming back to me, and tried my best to solve the queries as far as possible. Thank you so much, all of you, and wishing you all the very best. Stay blessed and enjoy studying.